Hi. So today I am going to share with you how a tenant can never be the owner of the property or can never claim adverse possession. So to understand why a tenant can never claim adverse possession, you must understand what type of possession is being enjoyed by the tenant and the principles of adverse possession, or the principles where you can claim adverse possession. Basically, there are two kinds of possessions. There are many kinds of possessions, but I would limit my subject here only to two kinds of possessions. One is the possession by way of a permission, and the other is possession without permission. If you own an immovable property, you want to lease it out to a tenant, you lease it out by way of a permission. You can lease it out by way of a permission, or you can lease it out without any permission. So if you lease it out with permission, it is called tenancy, and that is called the possession with permission. And if you lease it out without permission, then it is called non-permissive possession or adverse possession. But to claim adverse possession, there are some principles which the tenant will absolutely fail to prove those principles. Therefore, tenant can never be a owner. Tenant is always a tenant. Owner is always a owner, no matter what. The detailed principles for claiming adverse possession are that there should be an opening date of possession, because every possession starts with a date, and there should be a closing date of possession, that is the date on which court case is filed. So opening date of possession is important, closing date of possession is important, and this should not be less than 12 years. So if the opening date and the closing date is more than 12 years, only the adverse possession comes into play. And now, what is the type of possession? Whether it is a permissive possession or whether it is a non-permissive possession. Even if the rent is not paid, even the possession is gratuitous by the owner to the tenant, then also adverse possession fails. There should be an intention to claim adverse possession. It should be continuous. There should not be any gap within 12 years or more than 12 years. And it should be open. What is open possession? Open possession means the neighbors of all the properties neighboring your property, the owners of all the neighboring properties must acknowledge that the person or the tenant is the owner, which generally doesn't happen. The common knowledge says that it generally doesn't happen, that owner will be identified as an owner and the tenant will be identified as a tenant. Tenant will never have such kind of intention to become an owner, because whenever you are purchasing a property, owners identify owners and owners identify tenants. Therefore, that should not be an issue. So, the principles of adverse possession are that there must be an open possession, there must be a date for opening that possession, there must not be any sort of permission. That is, the nature of and the character of possession should be non-permissive in nature, and it should be continuous. It should be open, it should be peaceful. Peaceful means no court cases. And the fact of possession must be recorded. Now, whenever a tenant is coming into a property, tenant invariably fails in all these principles, in applying all these principles, because there will be some form of rental agreement. If the tenant defaults also, if there is a rental agreement, tenant cannot claim adverse possession, because there will be no intention. There is an intention only to default the rent, but there will be no intention to claim the property. There will be no identification as an owner of the property. So there are many factors for claiming adverse possession. It's not so easy as tenant dreams of. Hope I am clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.